我哋夠法定人數，亦都。
Members reform decorum is already the appointed time. May I call the meeting to order? Please invite the administration to join us.
上一次嘅會議裏邊呢
At the last meeting, some colleagues requested the administration to give us a more detailed introduction to the bill. So the administration has prepared a PowerPoint presentation for us to give us a better idea of the bill. Present for the meeting, we have Mr. Wong, Deputy Secretary for Commerce and Economic Development. You may start, Mr. Wong, when you are ready. Thank you, Chairman. Good morning. Well, since the last meeting, 3 months have elapsed, and would like to take this opportunity to brief members on the provisions in the bill, so to form the basis for further deliberation. Now, the purpose of a copyright regime is to promote creativity, and private property rights should be protected by law because it can be traded and licensed, and the right lies with the licensees or franchise holder. While property right is private, the right is not absolute. It should be subject to a certain time frame. Usually, it would only be there within 50 years after the passing away of the copyright owner. And for reasons such as public interest, use of copyright works should be allowed without the consent of the owner. And copyright has also got a territorial concept. Different jurisdictions can have their own legislative regime. However, there are international treaties to be followed, such as the very famous Berne Convention and the Agreement on Trade-Related Aspects of Intellectual Property Rights, and also the World Intellectual Property Organization's Copyright Treaty and the WIPO Performances and Phonograms Treaty, both signed in 1996. And most overseas jurisdictions will follow these treaties with their own copyright regime. For instance, the U.S. and EU, Australia, UK, Singapore, and New Zealand and Canada have got their own legislative regime. And in Hong Kong, we update our legislation from time to time. The original ordinance was enacted in 1997, and there have been amendments in 2001, 2003, 2007, 2009 because of economic developments. And then for the current bill, we started a public consultation in 2006, and then an amendment bill was introduced in 2011. But as members know, the original bill lapsed in 2012, and therefore we have introduced a new amendment bill 2014. There are 5 key areas in the bill, namely communication rights, copyright exemptions, criminal liability, civil liability, and safe harbor. I will briefly introduce these 5 areas to you. Under the copyright ordinance, because of copyright, the owner has exclusive rights to do a number of things, including to copy the work, to issue and make available copies of the work to the public, to perform, show or play the work in public, to broadcast the work or include it in a cable program service, or to make adaptation of the work. With technological advancement, we've seen new modes of electronic transmission, such as streaming. The current scope of statutory protection may not be adequate, possibly allowing an infringer to evade liability on technicality. So, following international developments, we propose to introduce a new exclusive right for copyright owners to communicate their works to the public through any mode of electronic transmission.
咁呢個就係我哋今次條例草案。
This is one of the most important amendments in the current bill. And of course, it is a balance. We want to protect copyright owners as well as general users. In the existing ordinance, there are over 60 sections specifying a number of permitted acts which can be done without the consent of the copyright owner, and they are for the purposes of research, private study, education, criticism, review, and reporting current events. To introduce the communication, while we introduce a communication right, we believe we should introduce some copyright exceptions to maintain the right balance between copyright protection and use of copyright works. This facilitates users to use copyright works under appropriate circumstances without obtaining authorization from copyright owners and attracting any civil or criminal liability. There are three areas already included in the previous bill. The first exception is to allow the education sector in communicating copyright works when giving instructions and facilitating libraries, archives, and museums in their daily operation and in preserving valuable works. They will enjoy exception. And the second exception is for OSP, online service providers, to cache data which technically involves copying. Such caching is transient or incidental in nature and technically required for the process of data transmission to function efficiently. For instance, you'll be able to see movies as a result. And the third exception is to allow media shifting. For instance, I've purchased a musical CD. I can change it to another format so that I can enjoy the music while in my car using an MP3 format. In addition to the three exceptions I just outlined, we've recently done a public consultation exercise on things like parody or secondary creation. So we have proposed three new exceptions. Now, if the purpose is for fair dealing, then exceptions will be allowed. However, they have to be used for the purposes of parody, satire, caricature, and pistache, or for use for the purpose of commenting on current events or for quotation. Why will we provide copyright exceptions to use for the purposes of parody, satire, etc.? Because the scope is clear and well defined, and it is well recognized to be a literary or artistic practice, and they are common means for the public to express views or comment on current events, and it's also relevant to freedom of expression. And such users may encourage creativity, nurture new talents, and may benefit our economic and cultural development. And many such works are commonly critical or transformative in nature and unlikely to substitute the original works. And in Australia, Canada, the UK, and EU, they have provided exceptions to such users in their legislation as well. The second area of exception added is quotation. What is meant by quotation? It refers to the extracts of certain copyright works. It can be commonly seen in academic literature. And even in common social media websites, we see cases of image capture and quotations on websites. They will help, they will facilitate arguments and dialogue and communication. So we believe there is a public interest reason for providing an exemption, and this is also the practice of the UK and other places. And the third exception is for commenting on current affairs. We already have a fair dealing exception for reporting current affairs to take care of expression interests of freedom of expression and public interest. Commenting on current affairs is also akin to reporting current events and should be given the same treatment under the ordinance. While we have expanded the scope of exceptions, there are principles to be complied with. First, it must be fair dealing, and should there be any argument on this point, the court has to take into account all relevant circumstances, in particular 4 factors included in the bill. First, the purpose and nature of the dealing, including whether the dealing is for a non-profit-making purpose. This is a very important point. Second, the nature of the work, whether the work is already published or distributed, and other purpose. And the third, the amount and substantiality of the portion dealt with in relation to the work as a whole. And 4, the effect of the dealing on the potential market for or value of the work will require the court to take into account these 4 statutory factors in deciding whether it is fair dealing. The factors for fair assessment are already applicable to those fair deal exceptions under existing copyright ordinance, and we've also made reference to the practice of the US and Australia, as well as relevant case law of other common law jurisdictions. And lastly, these exceptions have been carefully considered before their introduction, because in treaties there are requirements that exceptions can only be provided when certain conditions are met. First, it must be confined to special cases, and it must not conflict with a normal exploitation of the work, and must not unreasonably prejudice the legitimate interests of the copyright owner. We believe what we provide here are able to satisfy these conditions.
Next, criminal liability. Under the existing copyright ordinance, distribution of infringing copies is a criminal offense, and this would include doing so for the purpose of or in the course of any trade or business, or that you do so to such an extent as to affect prejudicially the copyright owners. We call this prejudicial distribution. This is already in the existing ordinance. Now we propose that criminal sanctions should include infringing communication, and we believe the same should be done for communication offenses. In other words, if you communicate an infringed work to the public, it would be for the purpose or in the course of any trade or business, or to such an extent as to affect prejudicially the copyright owners, then you should also be subject to criminal liability, and we call this prejudicial communication. With regard to the criminal threshold for the existing prejudicial distribution and the proposed prejudicial communication, quite a number of netizens were worried that this may leave the criminal net wide, so that there would be a chilling effect on the freedom of expression. They are afraid there will be legal uncertainty. To respond to such concerns, we have thought a lot about this, and we are now going to clarify what the criminal threshold will be. But unlike the last Amendment Bill, we are not going to adopt the phrase more than trivial economic prejudice because the meaning of this phrase may not be clear to many people. Rather, we are going to state the factors that the court has to consider in order to assess possible criminal liability. And precisely in the proposed Section 118(8)(c), we would write down that in determining whether any communication of the work to the public is made to such an extent as to affect prejudicially copyright owner, the court first may take into account all the circumstances of the case, and two, in particular, may take into account whether economic prejudice is caused to the copyright owner as a consequence of the distribution, having regard to whether the infringing copy so distributed amounts to a substitution for the work. We are singling out this substitution for the work for the court to consider. We believe this will help to clarify the legislative intent to combat large-scale piracy. And in our past consultation work, both copyright owners and netizens have found this a desirable approach. We'd like also to take the opportunity to clarify certain misunderstanding in the last discussion. In the last discussion, many people asked us whether the act of sharing a hyperlink would attract criminal liability and whether this would constitute infringement. I'd like to clarify that under the present legislation, if the link merely provides a quick access to another website, and the person who shares the link does not distribute an infringing copy of the copyright work, then this will not constitute copyright infringement. And then netizens also had this worry that if the copyright owner has given tacit understanding or has accepted the use of their works, but then the government might still institute criminal prosecution. But I'd like to clarify that this will not be done because one of the main elements of the offense is that if the copyright owner does not object or pursue the matter, there is no basis for the government to bypass copyright owner and take prosecution action because there will be no witnesses giving witness statements in the court. Number 4, the civil liability in the present amendment bill. I'd like to say that this is something very basic in terms of copyright infringement. If someone makes use of my copyrighted work, and I should be able to chase up on the other person under civil law. This is to right the wrong that has been done to the claimant. This is the general principle. But then this person seeking damage must bear the burden of proof of the wrongdoing and also the harm done. In practice, in many trivial cases in which copyright might have been infringed technically, the economic or other interests involved might not be sufficient for an owner to take out civil proceedings. And frivolous or vexatious civil claims would not be entertained by the court anyway. Now, of course, in upholding a claim, the court may award additional damages having regard to the following circumstances. This is already in the existing law. This will include the flagrancy of the infringement, also whether any benefit accruing to the defendant has been made by reason of the infringement, and then the completeness, accuracy, and reliability of the defendant's business accounts and records. Then the court may award such additional damages as the justice of the case may require. However, in view of the digital environment, 2 more factors are proposed as what has been proposed in the 2011 bill. And these are the unreasonable conduct of the infringer after having been informed of the infringement. Secondly, the likelihood of widespread circulation of infringing copies as a result of the infringement. We believe the court must avail itself to these factors before a reasonable award can be made to the one seeking the claim. Now I'd like to turn to something new in the bill this time around, and that is safe harbor. In the Internet era, very often we can distribute information because there are online service providers providing a platform for subscribers to upload their works. This is a kind of service by the OSPs. The OSPs just cannot tell whether the platform is being used for infringing activities. So we make reference to the practice of overseas countries, including the UK, Australia, New Zealand, Singapore, and US, to provide a safe harbor provision to limit the liability of OSPs. In other words, as long as the OSPs get information saying that there is infringing activity on their platform, and if they do something in order to stop this from happening, then that would be the limit of their liability, and they will not be subject to unreasonable liability under the law. And these provisions must be underpinned by a voluntary code of practice, which sets out practical guidelines and procedures for OSPs to follow after notification. Last time, we had actually started to write the code of practice when we had the last consultation. The current version of the code has been the product of the last 2 rounds of consultation, and the code has been scrutinized by the last bills committee. We hope the proposed safe harbor can balance the interests of copyright owners, users, and intermediaries, and provide an effective and efficient mechanism outside the court to settle allegation of copyright infringement. And I'd like to mention some points under this mechanism. Number 1, OSPs will not be required to actively police their service platforms for infringing activities, because this will be quite impossible for them to do. Secondly, a subscriber may choose to request the OSP not to disclose his or her personal data when it sends a copy of his or her counter notice to the complainant. In other words, when this is sent to the OSP has to notify the user. But while the OSP does so, the information of the user should not be disclosed indiscriminately. And if the user is not happy with that notice because he does not agree that there is infringing activity, then the counter notice can be sent by the user, and the OSP must take reasonable steps to reinstate the material. However, if legal proceedings have already been started by the owner in order to take the user to court, then of course the materials so reported should be removed. If there is the filling out of the notice and also a counter notice, now no matter who is doing this, the information so entered must be correct and specific. If there is false representation, there can be civil and criminal sanctions at a fine at level 2 and imprisonment for 2 years. We hope by having this practice, OSPs, copyright owners, and users may have their interests balanced, and also they can follow the guidance in the code of practice. So in summary, in the existing ordinance, some actions or behavior will not be regarded as infringement. First, the copyright owner has agreed or acquiesced. 2, the copyright protection in the underlying work has expired. And 3, only the ideas of the underlying work have been incorporated. And 4, only an insubstantial part of the underlying work has been reproduced. And 5, one of the permitted acts under the existing copyright ordinance applies. These are not infringing acts under the present law. Under the new amendment bill, if it is carried, with the introduction of the communication right mechanism, again as such will stay or remain lawful. However, we are going to introduce more into the bill in order to protect and preserve the freedom of speech, so that even without the consent of the owners, users can still use copyrighted works. As I said, the safe harbor will be beneficial to copyright owners, users, and OSPs. This is an introduction to the 5 main areas of the bill, and I will be very happy to respond to members to questions and answer any queries from members. Thank you very much, Mr. Wong. Any questions from members? Mr. Charles Smock. Chairman, I'd like to thank Mr. Wong for the introduction. He, of course, has done this many times. We have heard him many times, and he is very well versed with the bill, and we thank him for having a lot of exchanges with different stakeholders on the bill. I'd like to ask a short, notwithstanding a detailed question. You mentioned hyperlinks. You explained that if users or netizens just upload a hyperlink, they should not be worried because they will not be subject to any liability under the bill. However, I'd like to ask the question in a more detailed fashion, and maybe the DOJ can assist as well. Number one, very often the hyperlink is not just a hyperlink. It can make use of a social network, and then a preview will also be seen. If you click onto, or actually if you just open the page like on Facebook or on other platforms, you don't only see the hyperlink itself, but a short clip of the contents will also be shown. So will this constitute liability? Number two, in other ordinances, especially the Obscene and Indecent Articles Ordinance, the police and the DOJ have taken netizens to court saying that they have uploaded hyperlinks, and the contents of the hyperlinks are within the area of indecent or obscene articles, and those people were convicted at a magistrate's court. Some people say this will not form any precedence, but I'd like to know how these two ordinances are going to be different in terms of their treatment of hyperlinks. In other words, under that ordinance, people have been prosecuted and in fact they have been convicted for uploading indecent and obscene articles. But here you say there will not be an offense. What is the guarantee that this will be so? And also, can you also explain why the DOJ would carry out some tests? In other words, they are testing the bottom line to see whether a hyperlink can also form or constitute any offense.
Well, Mr. Wong assured us not to worry, but will the DOJ think differently? Will the enforcement, in terms of enforcement, they will try to test the bottom line to see whether a case can be convicted? Mr. Wong, at different consultation forums and our exchange with netizens, a similar issue was raised. It all depends on how the bill is drafted. Now, if you look at Section 13 of the bill, or Clause 13 of the bill, we have added new Section 28A is about the communication right. And in subsection 5, it says a person does not communicate a work to the public if the person does not determine the content of the communication. We have made it clear in the bill that if you're not someone who determines the content of the bill, you're just providing a hyperlink, then it is our drafting intent that it is not communication. So it is clearly defined in the bill. While I cannot comment on other circumstances, when the law enforcement agency enforces the bill, it has to know clearly the legislative intent and the purpose of the provisions. And the bill is drafted on this basis, and we believe the LEAs will respect the spirit of the bill. What about the point about obscene and indecent article ordinance? Can you tell us whether the two pieces of legislation are different? Mr. Lam. Thank you. And can I invite the Intellectual Property Department to answer? Regarding the obscene and indecent article ordinance, the definition for publication is different from what is in the bill. So, Mr. Mock talked about hyperlinks. They might have infringed that ordinance because their definition of publication is different from the definition of communication in this bill. Mr. Wong, in his presentation, said that if a person has no right to determine the content of the communication, then he is not communicating a work. So, uploading hyperlinks is not an infringement of communication right. As regards the details of the obscene and indecent articles or ordinance, I don't have the wording with me, but members may refer to the ordinance, and I'll see whether our colleague from DOJ can supplement. Chairman, while I'm happy with this answer, when we deal with that other ordinance, I think we should introduce sufficient safeguards for netizens as well. Ms. Claudia Mo, I have 3 questions. First, I really want to thank Mr. Wong. I know he has been lobbying different parties. Yet I have received submissions from netizen groups who have very strong views against this bill. They ask whether LegCo can refuse to scrutinize this Internet Article 23 bill. So it shows that your lobbying efforts are not entirely successful. So can you explain to us what are the reasons for that communication breakdown with these groups? And you said that in the court will ask the judge to consider all circumstances and the reasonableness of the case and so forth. So I think people will be taken to the court, and there's a dark cloud over the head of users. It's just like the stalking legislation. Journalists and editors don't know when they will be taken to the court and to invoke the public interest defense. I think this is psychologically a threat. While you say that you promote creativity, there's a sophistry. On the one hand, you are threatening me, and on the other hand, you claim that you're encouraging creativity. And number 3, Mr. Wong has been saying that even with without these exceptions, you can still be prosecuted under the current legislation. But the fact is, you have got very few prosecutions at this moment. Can you tell us whether you are giving people genuine protection? Because netizens are worried that you will only give exception if the users, for the purpose of a parody, satire, they have to act like clowns before they can enjoy exception. I think you're turning us into the mainland, because on the mainland you will be easily taken to court, and then they will deliberate on whether it is reasonable or not, and so on and so forth. We should have the spirit of the rule of law in Hong Kong. Well, even if you have the legislation, you rarely prosecute. But if the wording is so strict in this bill, then people can be caught easily. And for civil liability, people can claim civil damage very easily. And people can check the operation and so forth. So 3 questions. Mr. Wong, thank you, Ms. Mo, for your question. I'll try my best to answer your questions. It's true that last year we conducted a 3-month public consultation. During the consultation after, we have continued to contact her with netizens and users to explain what is about the bill. Ms. Mo asked what has gone wrong in our communication with these sectors. In fact, we have taken into account some of their concerns, such as more exceptions, so that they can use copyright works more comfortably. Now, things like parody and satire is already in overseas countries, and they've also asked now that more than trivial economic damage was too vague, and they wanted us to clarify. So we've already taken on board their suggestion, and we try our best to discuss with them, and we've come up with these proposals, providing an 3 additional exceptions covering parody, satire, caricature, epistage, quotation, and commenting on current affairs. These are the outcome of our discussion with these sectors. And for the threshold for criminal liability, we have get away with the use of trivial economic. Chairman, please ask Mr. Wong not to repeat his words. I think the only thing we cannot agree is user-generated content, UGC. Canada has got a special exception for UGC, but we believe this exception is controversial. In mainstream jurisdictions such as the US, the UK, and Australia have not adopted the UGC concept. So we believe this is controversial, and at this point, will an exception for UGC comply with the Internet treaties? We are doubtful. So we believe at this point we should not adopt UGC exception. But as I said, we amend the copyright ordinance once every few years. And the EU, the US, and UK, and Australia are studying their next round of amendments to their copyright regime. So UGC is also among their study areas. So we will keep track of what these countries do. And will all things be handled by the court? We understand that the law has to be certain. The certainty will benefit both users and copyright owners, because it provides a clear definition of rights of different parties, and people will have certainty as to what constitutes an infringing act. But when there is a big difference in view, then we should ask the court to decide whether it is fair dealing. I think it is a way to define rights. And through local and overseas case laws, we'll be able to let different parties know whether a certain act is an infringing one. And we have got a paper to explain what is meant by fair dealing and fair use, so on and so forth. that will facilitate the public to understand the definition of different rights. We do understand that there are bound to be disputes, and one party is bound to take the other party to the court. And I think through case laws we can then clarify different rights. And even in the U.S., the question of fair use has been established after many years of use and different case laws. Ms. Claudia Mo asked how we can offer genuine protection to netizens, and would only be able to enjoy exception if they act like clowns. We beg to differ from this view. For sometimes quotations and commenting on current affairs do not require the netizens to act like clowns to enjoy exception. And my last slide, I have talked about things that do not constitute copyright infringement under the existing law. And we are providing new exceptions so that users can use copyright works without authorization. So there is bigger room for users. And if you ask me whether it will be biased in enforcement to make the situation worse, I can only say that every other thing being equal, I think it is better to have a better piece of legislation that will offer more safeguards to different parties, and this is the spirit and purpose of our bill. Chairman, I left out one point in my second question. For the law on stalking, because it was very controversial, the government decided to shelve it indefinitely. And in the current copyright amendment bill, will you consider shelving the bill for a time being, if not indefinitely? Thank you, Ms. Mo. I can only say that the main spirit of the bill is to cater for our economic development. If we believe the creative industry is important, we must have a good copyright protection regime so that creative workers can make use of their copyright works to engage in economic activities and to promote the economy. We believe there should be appropriate safeguard for them for this form of private property. Compared with other countries, are we behind or ahead on par with them? Now, if we look at, we have to look at what's provided for in the internet treaties. The treaties are here, and because of the emergence of internet, many countries, including the UK, the US, New Zealand, Singapore, and the EU, they have their legislative amendments to reflect what's in the international treaties to protect international property.
We hope if infringement in Hong Kong is not checked, and if copyright creativity is not protected, and that's not good. We think this is a kind of reasonable legislative amendment and development. That is why we are tabling the bill to LegCo again. Mr. Yu Si-wing. Thank you, Chairman. With regard to the exemption, there is also the situation of communication for the sake of teaching. I'd like to ask about training for staff of a company. What do you think? And also, if there is exchange within a trade or training without any commercial element, then how do you view that? And also, if there is some kind of commercial exchange and some copyright works are used, what is your view on that as well? Mr. Chong. Thank you, Mr. Yu, for your questions. Let me talk about teaching or education. Under the present copyright ordinance, private research or classroom teaching are already exempted. In other words, even without the consent of the copyright owner, copyrighted works can be used in a reasonable way, and of course only to a reasonable extent. In other words, there should not be complete reproduction of the works. And now in the amendment bill, since there is the communication work and also to take care of development in technology, there could be long-distance training or education, and that is why we are going to expand the exemption. If schools use copyrighted works for teaching and also to convenience the learning of students, then intranets can make use of such copyrighted works. In other words, school intranets can be used to communicate copyrighted works to students, and students can make use of the works by the same channel. This is what we are proposing to do with regard to exemption for the sake of education. But if a commercial organization makes use of copyrighted works for internal training, there will be no exemption now. But when will an infringement occur? You may make use of the idea and you make use of a substantial portion, then that would constitute infringement. And in a commercial setting, if you only quote a small portion instead of a substantial portion, and then that is another situation. And by the same principle, if in a commercial setting, is it that whenever something is commercial, you cannot use any copyrighted works? Is it that you must pay a fee before you can do so? That is not the case. The same principle applies. In other words, in a reasonable way, you make use of a small amount or a non-substantial portion of the copyrighted works, then this is already a legal use. My second question had to do with non-commercial training or exchange within trades or industries. Do you regard that as education or teaching? Now, if well, actually, under the copyright ordinance, there is a clear definition of educational institutes. We include non-profit making education institutes, and that they are regulated by the Education Bureau, and also they are proper courses awarding certificates to students. But you talked about a commercial format, however, there is no commercial element. Then still it will not be regarded as education. But in a reasonable circumstance, you might not fall within the net of the copyright ordinance. First of all, please let me talk about a typo in the paper, because we should set a good example to the students. I'm talking about CB bracket 411 bracket 01 para 7. I thought we would discuss this paper. Yes, we would. In fact, there is a typo in the Chinese version in para 7 of that paper. Now, I'd like to ask a general question. Just now, Ms. Claudia Mo mentioned user-generated content, which is the concern of many netizens. After the Bureau has done a lot of lobbying work, still, you have not reached a consensus with netizens. Just now, Mr. Wong said, apart from Canada, this is not adopted by any other country. Actually, with technological development, and also because the commercial sector also has to compromise, I think this is a continuous struggle with the public interest. In the past, copyright owners would very strictly say nothing can be used, but now they have already adjusted their commercial formats. They are not going to seek huge profits in compensation, but they are only seeking to protect their rights. Some creative people, in fact, go online in order to make direct sales of their musical product instead of going through record companies. And also some entertainment companies also make use of advertisements instead of just depending on sales directly for income or profit. So whether it be technology or the law or commercial operation, everything is changing from day to day. Only Canada allowed user-generated content, but other countries don't, you say. However, in Hong Kong, we seem to have to rely on case law and other people's laws in order to formulate our own policy. Are we lagging behind other people as a result? In fact, in Hong Kong, the infiltration rate vis-a-vis internet is so high in Hong Kong that we rank 5th or 6th around the world. In Hong Kong, litigation fees are also very expensive, and local users may not be able to seek compensation, so that we do not have our own case law. However, we therefore have to rely on other people's case law in order to make our laws. I think the administration should pursue our own case more closely so that you can rely on local sentiments and the local situation in order to formulate our own laws. This is number one. Number two, Mr. Wong said many countries did not use this. Can you not tell us more why they did not use it? Under what circumstances did these countries decide not to use it, and why Canada has it? I like to be in the big picture. I'm sure netizens themselves will search for the information, but to be fair, the information that comes to us will say, yes, we should have it, but information going to you may say, no, you shouldn't have it. So I think we should have a symmetry of information. And then Mr. Wong also said that without the consent of the copyright owner, then there will not be any witness and there will not be a case. But then a case may still go to court. Who decides a case should go to court or not? Our main reservation about criminal cases is such that you don't need the copyright owner to make a report to the police. Anyone can report to the police. That is our understanding. But according to Mr. Wong, well, yes, I believe that is going to be a fact, and that is if the copyright owner himself does not come forward, then you may not have all the evidence you need. And you also say that even tacit understanding or a consent is allowed. But still, there may still be people taking these cases to court. Now, I'd like to ask about our original ordinance. Do you still have to seek the consent of the DOJ before you take out prosecution? If there is this provision, can the administration stop frivolous or vexatious attempts to take people to court? Maybe you have a quarrel with your neighbor, so you report him to the police saying that there is an infringement, etc. Number three, parody and the rest. You now want to act comments or make it funny before there will be exemption. My communication with the officials has been that if you look at TV news reporting, of course, they don't want to make it funny. They just want more people to be able to know this. So they place it online. And websites of TV stations would carry this icon saying that redistribution is welcome. We can call that tacit consent. And then the freedom of communication will be initiated by the TV station. But if a fee is going to be charged later on, then the public will not be protected as long as the right of or right to know is concerned. So can I ask you whether you can allow such lawful communication to go on? Thank you. Thank you. I'll try to answer all the questions. Number one, prosecution. My understanding is that the initiative to prosecute has always lied with the DOJ. That is our constitutional setup. They have a very clear prosecution guideline and policy, which is in written form, and the entire society knows when prosecution will be taken out or not. If someone complains to an enforcement agency that there is an infringement case, then the enforcement agency has to look at the elements of the crime. They must look at the elements of the crime. As I said, under the infringement law, one of the elements is without the consent of the owner. So the first thing the enforcement agency has to investigate into is whether there is consent. The enforcement agency must clarify that point before the DOJ will consider prosecution under their policy. So it won't happen that if the copyright owner has given consent or tacit consent, the case will still go to court because one of the elements of the crime will be absent. Number two, overseas situations. Why many countries do not make use of user-generated content. I can add, in Australia, they have their Law Reform Commission to review the entire copyright law to see whether they need to do something to catch up with the development of the Internet. They have looked into the Canadian mode. They don't want to follow the Canadian example, and they have a lot of justification to say that this is controversial. They have gone down the route of fair dealing instead. The U.S. last year, their Department of Commerce issued a green paper last year. The U.S. has got this Digital Millennium Act for 10 years, and they have taken stock of their experience, and they highlighted UGC, but they felt that they did not find the need to preserve UGC by law. And the European Union, they would like their member countries to take forward their copyright laws. They have looked into different issues, including UGC, and they asked member countries what they would like to do with UGC. The UK said that they did not think the European Union should adopt UGC. The UK itself actually also reviewed its copyright law a few times in order to help countries go digital. But in the end, they decided against it. But Ireland has looked at their law reform and also to see what should be done about their copyright laws. They thought that the Canadian mode was desirable and they proposed laws. But then we cannot see any implementation after 1 year has lapsed.
A year ago in the Trade and Industry panel, we provided a paper. If necessary, we can provide the paper to members. And regarding free flow of information, is it true that the copyright owner has all the say? Now, it goes back to who is the copyright owner. Of course, in a news report, the journalist spent efforts in preparing the news report. He has copyright, and it is for the purpose of business. Now, even if he doesn't use it, still he owns the property. We've seen cases where people used pictures published in another news report. It was not allowed because it was an infringing act and there were claim cases. And recently we have seen similar cases. So all I can say is we have to respect the copyright owner himself. The pure argument that the public have the right to know more is not an excuse under the bill. But for fair dealing, this exception is always here, and the court will have to decide based on the 4 factors. And are we being too passive? Do we always have to follow the footsteps of other jurisdictions? If we look at mainstream development of copyright regime and also internet or international treaties, and the UK, Canada, Australia, and the US have done something to amend the legislation. And if we stay put or mark time, it is indeed a backward step. We'll not be able to fully utilize the potential of Internet as a new form of economic activity to promote creativity. Is UGC, in terms of UGC, this concept is only adopted by one country. And can something be directly uploaded to the internet without a middle person? And if it is not for profit, now this is already happening. Whether it be in Hong Kong or the US, this is already happening. Well, these countries have clearly laid down who has the copyright using their existing legal framework. And in their existing legal framework, there is no UGC still is able to stimulate people to use technology for promotion of business. So I think we have to use the bill to protect communication right. Chairman, I'm not a member of the relevant panel. We can take out the paper from our website. But Mr. Wong has told us different approaches by different countries with regard to whether they adopted UGC exception or not. I hope Mr. Wong can give us a paper on the rationale behind the different approaches adopted by different countries. And regarding prosecution, my question is very simple. In this ordinance, I'd like to know whether it's just like other pieces of legislation, that is, prosecution can only be done with the consent of the DOJ. In some ordinances, this is an explicit provision. All right, your question is very clear. Can I ask Mr. Wong to answer? Chairman, please allow me to finish first. Of course, in general, I'm against criminal sanctions for infringement, but to provide better safeguard, there should be consent from the DOJ so that complainants or departments will not prosecute very easily because they are not too sure about what the spirit is about. And regarding the use of news reports, many free TV stations are called wishy-washy, and they are not doing a good job. As for some paid TV stations, people think that their news reports are more impartial and balanced. And of course, there is a commercial interest in buying news. But news is about current things, is refreshed daily. And if somebody puts it on the net for distribution, I don't think it is an infringement. I know some commercial organizations copied news reports from other organizations for their own business. This is indeed an economic activity, and this should not be permitted. I don't think people will object if you regulate such activities. But if individuals are distributing news reports of the previous day, for instance, in their for the public, I think this is not business. And I know your position is very different from mine, Mr. Wong, but I think I have to raise this issue and see whether there can be a public debate and amendment to the bill. Mr. Wong, thank you, Ms. Ho, for your question. We are more than happy to provide a paper on considerations by different jurisdictions as to whether UGC is adopted. And regarding prosecution, if my memory serves me, or in our basic law, our mini constitution, it is clearly set out that prosecution decision rests with the DFJ. That is our constitutional position. And whether it is in the bill, I'll ask my colleague to supplement later. And if we talk about a fair dealing exception, there is room for ordinary members of the public to make use of news clips for communication privately. For instance, such as commenting on current affairs. This is one factor of fair dealing. And if a media organization make use of a news clip from another organization, of course it is for commercial use. It is not fair dealing. But between friends, a certain news clip is used to facilitate communication and debate. I think there is room for this to happen. This is not absolute. Mr. Wong, can you be more specific and give us a paper on this point? All right, can you wait for the second round? Because you've spent more than 20 minutes on this. All right, Mr. Wong, please give me a paper on this specific point. Mr. Ronnie Tong. To a certain extent, exception for parody is just like the Occupy movement out there. There can be no solution that is perfect. No matter how wide the scope is, people who are beyond that scope will not be happy. Some legislators may not want to offend the netizens. As a result, the bill might be aborted. We spent 2 years to scrutinize the previous bill. No matter how hard you try to explain, you cannot make your proposals acceptable to netizens. And the fact is, while secondary creation has been a criminal offense for many years so far, there's been no single prosecution. Since there has never been any prosecution, my understanding is our international obligation rests with enacting the legislation. Since there is no prosecution, why do you want to overturn the bee's nest? Because there are not a lot of things we have to legislate. There are many other urgent matters. So I don't think this amendment to cover parody and other things is not a good thing. I think your efforts will be counterproductive. You will not be supported by netizens. They will only chase after you. Currently, netizens feel secure with the amendments. They will lose this sense of security, and this is really satirical. Yet in Hong Kong, we have got lots of such things, and we have to face up to this reality. All right, if netizens insist that they will not accept any explanation to let them understand the reality, will you agree that withdrawing this part of the bill is the best way to get your bill passed? Thank you, Mr. Tong. Of course, we are not doing anything in particular to stir up the feelings of netizens, but that's the effect. All right, we are just proposing legislative proposals for the legislature, and we, in good faith, believe that this will be of great significance to our economic development, judging from overseas experience. So we are introducing communication right and also a safe harbor. And we've been told by many people that if we just introduce the communication right, then the balance will be tilted towards the copyright owners, because the exclusive rights of copyright owners will be expanded, and these people feel that it will be risky to users. So we have conducted an other public consultation. We asked if we want to maintain this reasonable balance, can it be done by providing more exceptions? And the answer is yes, and therefore we've introduced 3 new exceptions to protect the legitimate rights or reasonable rights of users. And we believe that is in line with developments in other countries, and they are able to do so in their legislation if it is found to be helpful to users in other jurisdictions. Why don't we follow suit? So the bill is introduced as a package to the legislature, and the purpose is to help copyright owners to continue to create wealth and to bring economic development and benefits. We want to ensure that the use of the works will not prejudice their interests. Users will be able to continue to use their works not for economic gain. Ms. Ronnie Tong, I have no follow-up. Mr. Raymond Wong, Chairman. Your conclusion talks about the existing law. I don't think this is the existing situation. It will be after the amendment. No. Under the existing law, 1, 2, 3, 4, 5 is not an infringing act. The existing copyright law is very outdated. If you consider the history of the amendment and amendments of the bill, you will agree that the law hasn't caught up with technological development, and our concern is about the legislative intent of the current amendment bill. Now, if you say that the purpose is to improve our intellectual property regime and to promote creativity and to ensure that copyrights will be properly protected. Now, if this is your legislative intent, of course, we will support you. However, there are 2 main concerns. First, free flow of information and freedom of information. When you amend the legislation, you must provide a balance. And second, we're concerned about the freedom of expression.
This is our basic position with regard to this amendment bill. As I said, you say the original intent of the bill is to allow intellectual property to be given appropriate protection under the law. However, you still have to balance the 2 principles I read out. You have to be mindful about the contents of the law because the devil is in the details. By reading the papers supplied by the administration, including the discussion in July, we mentioned some controversial issues, one of which is let us look at criminal cases in copyright infringement. The administration clarified the prejudicial distribution offense and also the proposed prejudicial communication offense. We welcome the abandonment of the composition more than trivial economic damage. But then in para 5, it is said that clause 57 of the bill does not exactly define prejudicial. I'd like you to explain why. After reading the papers, and also in para 9, you mentioned the Chen Naiming case, and the presiding magistrate considered that the phrase prejudicially, he was of the view that this was not defined in the ordinance, and he considered the elements constituting prejudice. These are common law cases. Would the administration look at these cases and come to a view as to what elements would constitute prejudice and put them in the bill? In para 5, you came up with 4 points about prejudice. And this is in the paper, Criminal Cases in Copyright Infringement. You mentioned 4 things that would constitute prejudice. Then why do you not include them in clause 57? This is my first question. This is the question on interpretation or definition of prejudice. Number 2, you provided 2 papers from the Intellectual Property Department in order to respond to the views of replacement work and also fair dealing, fair use. Before we study the bill, I think these have to be clarified. Number 1, a replacement or substitution of the work. The bill proposes that the court should consider whether such a work is distributed to the extent of prejudicing the benefit to the owner, and also whether the communication would constitute a substitution of the work. The use of the principle here must be controversial. The IPD paper carries a few examples, including BitTorrent by Big Crook. Now, of course, this would affect the interest of the owner. But if it is only a portion used, does that mean it constitutes a substitution? If a soccer match going on for 90 minutes and only the most attractive bits are uploaded to the internet, and since those people watching it on the internet may not watch the entire match anyway, then would that constitute a substitution of the work? But what if just some funny clips are used? Remember the Uruguay star, the soccer star who bit his opponent. People would be clicking onto that all the time, but how would that constitute a substitution of the work? If you were at the scene, everybody was shocked, and that soccer player was enjoying the moment. And in fact, less than 10 minutes of the bite, the clips were already on the internet. Usually the clips were from overseas, and then people parodied it. People showed the soccer player biting other things and other animals instead of a person. So that would not be a substitution, I believe. And I'm talking about the Uruguay player Luis Suarez. And what if people also upload short clips of a film? You know, there is this drama on TVB. There was an actor lashing out at property tycoons in Hong Kong. That was uploaded onto the internet. Many people watched it, but the TVB company said that that constituted an infringement, so he sued the people doing this. But actually, even if people click onto that funny bit, people would not refrain from watching the entire drama. the people would actually be attracted to view the drama on TV rather, and TVB would be able to get more income from advertisements. You have to clarify all these. And then on fair dealing, there is this concept, and some netizens would support the UGC concept, the user-generated content. In other words, a user would make use of content not for profit as long as there will not be any substantial prejudice to the original owner or replace the market for the underlying work. Then the introduction of the exemption could in fact protect the freedom of secondary creation. I have met with relevant groups in the past few months. Some supported and some objected to having UGC. I have talked to them, but there is no consensus. For example, some keyboard warriors, and also there is a concern group on secondary creation. I think you are clear about this. We are talking about UGC that is not for profit. We believe there could be exemption for both civil and criminal liability. I believe this will allay the worries of the users who then do not have to worry about economic prejudice done to the owner. And then some of the people objected also. For netizens, they do not have to worry about prejudicing the economic benefit to the owner. However, some other people are worried that this would amount to a platform for infringement. My own view is that this concept will continue to develop with the advancement of technology. We are now lagging behind technological advancement. This will allow the law to follow closely internet development. Just look at handsets. Whenever you have a new model of handsets, you have new software. This will also protect the freedom of creation of netizens. When I talk about netizens, I would say that they are just the public who now doesn't make use of the internet. Once you use the internet, you become a netizen, and that includes you and me. When I'm speaking, some of you do not pay attention and you are surfing on the internet. You are a netizen now. I don't think you should set netizens against the copyright owners. I am also a copyright owner myself. So, Mr. Wang, this is very complex. I have to set the scene. But you have asked many questions. I have no questions. It just has to answer me 2 questions, and then I'm going on with my comments. I will say even more when we come to the scrutiny of the bill. Let me tell you this. Introducing UGC will not cause any economic prejudice to the owners. You have to consider this. You have to give us a clear-cut answer. Some members asked you for overseas developments. For example, Canada. How is that being implemented? Let us have specific comparison amongst places where there is UGC and where there is not. Mr. Wang, thank you. Thank you for those questions and comments. Number 1, prejudice. Mr. Wang, you asked a very valid question. Indeed, this is not defined in the law. If we look at the legal provisions on criminal liability, they are quite similar to the Australian and UK laws, which have also used the word prejudice. But then other countries did not define the word either. We believe this is not ideal. Mr. Wang asked whether we should write down the elements of the crime. Actually, in the 2011 bill, we clarified that, in fact, we included 5 elements under the word prejudice to explain what it means. After 1 year's scrutiny, and also after discussing with the then Bills Committee, we came to the view that there should be a CSA, which was agreed to by different parties, and that the 5 elements should be rewritten into 3. Now, in this paper, in para 16, footnote 9, we commented on this. And we have included the arrangement of replacement. But it's just that it is not mentioned. And then we are going to conduct consultation because we have to talk to users whether the new definition is good. As you observed, we were quite polarized in our stance, but we could agree on one point, and that is whether that constituted a replacement of the work. We said that that should be included in any case. We looked at case law, and now we have asked the court to give consideration to all circumstances of the case, in particular economic prejudice. And so this is the spirit following the development in the past. This is what we are going to propose to include in the law now, and this is the product of previous consultation. But certainly we can continue to discuss this with the Bills Committee, whether this approach is quite reasonable and good, or you prefer other definitions. On the other hand, replacement or substitution of the work, as illustrated by Mr. Wong's examples, those would not constitute a substitution of the work because it would not replace the market for the underlying work. In fact, the criminal threshold will be very high, and the court will be able to know that such acts would not constitute substitution of the work, and there would not be any basis for prosecution. That is why we are proposing to do this. I agree with Mr. Wong, and the administration has always accepted this, and that is when we seek to amend the copyright ordinance, freedom of information and freedom of expression must be considered because they are important public interest, and we should not just seek to protect private intellectual property. Therefore, there are a few exemptions in the bill in order to tackle the examples Mr. Wong quoted. For example, parody or sarcasm or satire. If you bite a certain person, for example, if it is parodied, and then that would fall into the net of fair dealing. Apart from biting people, say in a soccer match, some people fly kicked a soccer ball, and that was very often clipped and enjoyed by internet users, and that would not constitute a substitution of the work. This is what we have done, and we have clarified the wording in the bill.
Yeah.
And quotation, if you extract quotation from a certain work to substantiate your argument in social media, there is exemption in the bill. And Mr. Wong just reminded us that every one of us is a netizen. We do understand that it is a term. In fact, a user is a more neutral term. Everyone can be a user. And we have to strike a balance between protection of the interests of the copyright owner and the user. And we've promised Ms. Sit-Ho that we're going to prepare a paper on UGC and whether it's been adopted by different jurisdictions. Mr. Gary Fan, I've got two questions. First, on the exemptions and also how the economic interest of the copyright owner can be protected. When the administration amend any legislation to enact any legislation in relation to IT, it should be forward-looking enough to anticipate new technological developments. Now, secondary creation is prospering because of a very mature development of the Internet in Hong Kong, and the amendment bill offers some exemptions. It mentions things that is permitted, but not things that are not permitted. In other words, it is regulating communication methods and modes that may emerge in the future, and I think this is detrimental to creative development and promotion of the creative industry. Now, with UGC, I think the greatest merit is it will not limit the method of creation. When we discussed universal suffrage, Sui Leung CE said that we should not consider international standards. And now, when we discuss UGC, they ask us not to come up with an international standard that is non-existing. I'd like to ask Mr. Wong whether you can consider views of the public and allow UGC exemption and fair dealing to coexist. And Mr. Wong mentioned the protection of the economic interest of a copyright owner and to continue to promote creation. And yet he criticized the UGC concept for being rather vague. But UGC will not restrict the mode of creation or the method of creation. If the spirit of the bill is to protect the economic interest of the copyright owner, then shouldn't we narrow it down to the following scope, so long as the owner of a secondary creation is not for economic gain, that would be allowed. This will be a balance between the protection of the interests of the copyright owner and that of the secondary creator. I think Mr. James Wong, another very famous member of the creative industry in Hong Kong, said that creativity has to be based on something, and you can create good works out of existing works. There are many people who support secondary creation. They don't like the current and preceding discussions because they understand that the bill doesn't regard secondary creation as a form of recreation. Now, you provide an exemption for the purpose of parody, so you do agree that parody is a form of creation, but you have screened out some other forms of creation. Now, why is it that when Lo Gai-ying, a local artist, sings only you in a funny manner, that is a secondary owner, but not in other cases? Mr. Griffin, now I am almost done. Well, Mr. Fan, no. Mr. Wong. Thank you, Mr. Fan, for your comments. I'll respond to your points one by one. First, whether we should provide exemption on a case-by-case basis, and do we have international standards to follow? As I explained, there is territorial application of copyright, and there are also international treaties that we all have to oblige. Under TRIPS Section 13, there is a three-step assessment system. First, we accept that copyright is a private property right and should be protected. Without the authorization of the property owner, it should not be used. And secondly, there is a three-step assessment. First, exemption should be confined to individual cases. The use will not conflict with the original work, and the interest of the copyright owner would not be prejudiced. Well, we then decide how to introduce these standards into our legislation, and this is the same practice in countries like Canada, the US, the UK, and Australia. We don't believe that in fact, the exceptions we offer here have catch up with many jurisdictions. We also offer technological exceptions. Is it true that there are things that cannot be done, undermining creativity because of the exceptions? We don't think so. We've discussed with users at length. Now, let's not use the term UGC. What are the acts that are being currently done on the website, on the internet? Will they still be permitted after the bill? Now, we discussed at length. We believe that what we propose have covered the majority of acts. Now, Mr. Fan, you talked about the singing of a song. Is it a creation? Is it a limitation? Public performance of a copyright work involves some economic interest. There is an organization that charge a royalty so that the party concerned or somebody concerned can have economic gain. So in a concert, if you perform a song, you have to pay royalty before you're allowed to sing a certain copyright work. But there are also some other very good arrangements. For instance, in LCSD venues, when you hire a venue, you have already paid a royalty. So you don't have to pay extra if you perform copyright work. This is the current arrangement. So we accept that it is a copyright work, and the economic interest is because it can be broadcast or sung in the public or by downloading on the website. Then we cannot allow a practice that may substitute the original work without any restriction, and therefore we do not offer any exception in this case. But that doesn't mean that a lot of things will not be disallowed, such as video or picture capture, image capture. It is for social networking. I capture a certain image and I write a caption or a legend, and it's about Lo Ka-ying singing that song, for instance. Well, we offer a new exception in the bill. We've introduced a fair dealing. If it doesn't cause any economic prejudice, then you will not be prosecuted. So that's providing exception on a case-by-case basis, and this is in line with international standards. And is it the case that so long as the original creator does it not for economic gain, and that is okay? But now, if it is for economic gain, of course, there is the question of infringement. But if the work will substitute the another work in the market, if it will prejudice the interests of another party, then we have to protect the legitimate interest of the copyright owner. So we believe what we propose here has struck a reasonable balance. We're able to take care of the interests of users. Their interests will not be undermined, and we do accept that secondary creation may be very creative, and many such creation is based on original works. Now, if you're using original ideas and not the substantive part of the works, then it is not an infringing act. But if you have used a substantive part for adaptation, for instance, we have to protect the interests of the original copyright owner. For instance, the production of movies from comics or from a book, the comic itself has copyright, and you adapt it into a novel or a movie, then under the copyright regime, well, the interests of the copyright owner should be protected. Now, if I make a movie about spies and the protagonist is not James Bond, although I have built on that concept, well, this is already being done. So we have to make a distinction in law. Thank you. Mr. Chen Chi-chun. I'd like to discuss with you some concepts that are very important and related to money. There is the question of profit-making, commercial nature, economic loss, or prejudicial distribution. Very often, parody works. Well, the prime motive is not for profit-making, but the objective result is the owner may generate interest. For instance, I have made a parody of a certain work put on my platform, and because there have been innumerous hits, and I got to share profits with YouTube, and advertisements are placed by YouTube, then is it considered profit-making? Or is it that so long as my original motive is not for profit and or to substitute the original work, I be given exemption both criminally and civilly? Well, the parties concerned can be political party A and B, and also medium organization. Well, party A has got, say, a video or an image, and party B got tens of thousands of hits after using that for secondary creation. So will party B be exempted? I'm afraid that now if you do not gain any economically, that is okay. But if you turn out to be a big hit and you get profit out of it, will you still be safe? Thank you, Mr. Raymond Chen, for your question. On YouTube, well, is the original motive important? My understanding of YouTube is that if you don't want to share the profit, you have every right to opt out. I think this is a relevant consideration. And regarding substitution of the original work, if the secondary creation substitutes the original work, it is indeed an infringing act, because it would prejudice the original work. But if you have adapted that into something else, then it depends on whether it is a parody or a comment of a current affair.
This is actually quite happening quite often on the internet now. If this will fall into the fair dealing net, then there could be freedom from liability. Well, okay, if I forgo my own economic benefit, then it's all right. But if I don't choose to do it and it happens, then does it mean that I could be criminally prosecuted? Is there overseas experience, Mr. Wong? This depends on what a fair dealing can do. Maybe Ms. Chong can answer. Mr. Chan, you talked about not-for-profit and how that will be defined. That actually tells us that the Canadian mode of UGC is controversial even within Canada because it is difficult to define what is not for profit. If I upload a movie, I don't want to make a profit, but at a certain rate, the hit rate is very high, so I get some profit because there will be advertisements on YouTube. We sought an understanding with Canada. If by a certain stage, if a profit is made, even if the intent is not to make a profit, Canada has said that at that stage, the user should seek the consent of the copyright owner, or else he can no longer cite exemption under UGC. This leads us to the point. If we go for UGC in Hong Kong, can we really make sure that users will be happy? Because at a certain stage, they will still have to assess their own risk, and they may eventually have to pay the copyright owner. And will these be meeting the demand of the users from Canada? That is not the case, because originally it was not for profit, but at a certain stage profit is generated, and it is not sure whether exemption under UGC can still be claimed. And I'm talking about the civil liability. Exactly, this is the question. Some secondary creation may not receive any attention in the first half year, and then suddenly it becomes very hot and goes viral, and then a profit is generated. Well, this is not a case of profit making in our view. Many people want to draw the line as to whether profit is generated, but in fact we would like to counter-propose that if within a reasonable limit for some appropriate aims, for example, for personal research or education, and also commenting on current events and a quotation of certain works for public discussion or parody or even pastiche and also sarcasm, etc., or satire, and also caricature, we like to go for that instead of using the concept of UGC. We would say this is better than drawing the line at personal use and not for profit. Well, I still haven't got my answer. If my motive is really only for reporting and commenting on a current event, but the objective fact is that I get $1 or 1 million in return, would I be exempt? If it is about quotation and commenting on current events, and in the end you get some economic benefit because it goes viral on YouTube, then we have to look at the 4 elements under fair dealing. It actually states that if you do it for commercial purposes, but in the end it goes viral, however, it doesn't constitute substitution of the underlying work, then you can still enjoy exemption under fair dealing. In other words, if for a specific purpose you want to comment on a current event, you satirize a current event, and in the end you get some economic benefit, it doesn't mean that you will not enjoy the exemption under fair dealing. Members, 2 more members would like to ask questions. Our meeting should end at 12:45. Now I'd like to resort to fair dealing. I will allow the 2 members to finish asking questions before we finish. Mr. Ma Fong Kwok and Mr. Martin Liao. Thank you, Chairman. We have discussed amendments to the ordinance on copyright for many years. The SAR should keep pace with the international community, and at the same time we like to protect private property. I think so the bill is absolutely necessary, and in fact the major portion of the bill is not controversial. For the cultural and creative industries, they would like the bill to be carried ASAP. 2 years ago, there was some controversy and it was shelved. And in the past 2 years, the administration has done a lot, and I believe we can support it. The thing is, now we have a new bill, and it makes proposals for adjusting the controversies. I may not be able to represent all my constituents, but after consulting the industry, their stance is that basically they can accept the proposed version, that there should be reasonable exemptions. And I'd like to state a viewpoint. In the past 2 years, discussion in the community seems to be they put creativity against the freedom of creation. But to the industry, these two should be united. The thing is, you have to balance the two, so investors who are taking the risk should have reasonable returns. And the reasonable return should be distributed to the original creator and also other people who have contributed to that creation. So the crux of the bill should be to balance the interests. And also, of course, there is the freedom of expression, which is the public interest. The industry would like to protect that as well. So let us not just set one thing against another easily. I would represent my industry and say that I object to what Mr. Wong Yok Man said. Of course, we treasure our freedom of creation. The administration has said that we can have fair dealing, and it has introduced certain exemptions. But then we also have our international obligation, and there are international standards. Just now, Mr. Gary Fan said that sometimes the administration refers to international standards, sometimes not. For me, an international standard is a kind of treaty or convention that has been signed by the countries who all agree to it. That is an international standard. But in the present constitutional development exercise, it seems everybody is talking about different international standards because there is not an international standard that is set in stone. But then in terms of copyright protection, there is an international treaty. And we can do our work most effectively by following that international treaty. There is the 3-step test. I think that is very reasonable. So what we should do is to follow the international standard to which we have been extended. I think that is most reasonable. But on the papers from the administration, I have 2 questions. In Annex E, it is said that in 2014, the UK has included new exemptions. I'd like to ask how... Sorry, Mr. Ma Fong Kok. I'm asking questions. Yes, but those 2 papers have not been gone through. We will discuss those papers at the next meeting. Is that okay? I still have another question. Okay, I can leave that question for next time, but there is another question. Okay, as you can see, technology is advancing every day, and there are new ways to infringe works. For example, TV box, and there are new issues of infringement. Now you have got this bill. I'd like to know whether you will do something about such TV box. Some manufacturers have done something to prevent infringement. However, some wholesalers or retailers have neutralized that secret code, so there could be infringement. For people in the broadcasting industry, this would mean a lot of economic loss because they are paying huge money into getting the transmission rights. So will you do some fine-tuning so that you can also tackle such new infringement acts? Mr. Wong, thank you, Chairman. We are always very careful in proposing any change to the copyright ordinances because different people's interests are involved. We are aware, of course, about these TV boxes. The Customs and Excise are liaising closely with the copyright owners to see whether there is any infringement. And we have enforced the law. We have tackled such cases. Anyway, the basic thing is these so-called TV boxes make use of streaming in order to allow people to receive TV signals. And in fact, this is also something that we seek to deal with. I hope the bill will be carried as soon as possible so we have the foundation to tackle this. I'd like to respond to Mr. Raymond Chan's question, and that is doing something together for profit. Maybe we can discuss this further at the next meeting. But when we consider whether it amounts to fair dealing, now if something generates a profit or monetary return, how would the court consider this against fair dealing? In fact, we have cases including the movie Pretty Woman and Gone with the Wind, and also another one. This is not an overriding consideration, but we have to set it in context. But we can discuss this next time. Mr. Martin Liao. Thank you, Chairman. In the law, there cannot be a law that is absolutely clear because it is not possible for you to foresee any new developments. If there is, Paul J. and myself will have to resign from our profession and farm the land again. It depends how the court views the cases. Chairman, I think the previous and the present discussion has been limited to the technical level, but society is not given the macro policy viewpoint or consideration. Copyright is an intellectual property right. It is a kind of exclusive right. And there is a social price to pay. And also, the people who infringe it would be distorting the market economy. The thing is, why do we want to give the rights to the copyright owners? This is because we want to encourage creation, and only with creativity can we have advancement. That is why we want to provide a legal framework for the owners to enjoy the results of their creativity. Even if there is a social price to pay, we want to protect intellectual property. And in doing so, other people's rights may be affected. And policy-wise, you should explain the background to this and why, policy-wise, you need to balance the interest between the copyright owner and the public, and why you have to explain to the public why the bill has achieved that balance. I don't want to spend your time or use more time on other matters. I can defer those to other meetings. I think, Mr. Wong, you have been quite clear about this.
Thank you, Mr. Liu, for reminding us. Yes, I think we have to make clear the policy on a macro perspective, because why do we want to protect the interests of copyright owners? Because even intangible works can bring economic gain, and therefore we should protect the owners. The law originally protects tangible property, including your land or your flat and this and that. And when we clearly define and protect property rights, then people would work hard for economic gain. Copyright or intellectual property is intangible. Our economy has developed to such a state that such works do have an economic value and should be protected, and they should be protected on par with the approach we use for tangible property right, so as to promote the creation of more intangible copyright works that carry economic value. But you have not explained that clearly enough. People do not have this perspective. You only argue the technicality of the bill. You would never get a consensus, because intellectual property right users will say that there should be no protection at all. For the owners, they want as many rights as possible. How do we strike a balance? We must do so by building up a macro perspective, and that everyone should be clear about it. Yes, thank you very much. We do agree that we should explain at a macro perspective why we need to protect intellectual property. Now, we accept that private property should be protected, and we also accept that some users are reasonable, and that's why we have provided exceptions for copyright works to be used in a reasonable manner. And we have a 3-step assessment provided in international treaties. Now, it should be confined to individual cases, and second, it will not cause any prejudice to the legitimate interests of the copyright, and it will not be a substitute of the original work. And these exceptions will ensure a balance, an overall balance, so that people who can create intellectual property works will have the incentive to continue with their creation, and to ensure that users can continue to use intellectual or copyright works in a reasonable manner for freedom of expression, flow of information, for sharing, so on and so forth. So, with this broad picture, we would like to apply this concept to electronic transmission of copyright works. We do understand that we should update some of our exceptions to see what's happening in the internet. For instance, quotations and parodies. Some countries are already giving such exemptions, and therefore we decide to add it in our bill. Thank you very much, Mr. Liu, for your reminder. I think Mr. Liu is asking you to talk more about the purpose of enacting the bill, how you can protect the interests of the copyright owners and the interests of legitimate users. I'd like to remind you that at 9 a.m. on the 25th of October, we will have a public hearing in this room. We notified a member on the 30th of September, and we've also issued invitations to the public. So far, not too many organizations or deputations have indicated their interest to come. So depending on the situation, originally we've scheduled a meeting from 9 a.m. to 7 p.m. I hope you can make available this slot in your diary. Date of our next meeting will be on the 11th of November, on the 4th of November. And we've also prepared a schedule of meetings for you. Please note the meeting schedule, and before each meeting we will issue a notice of meeting to remind you. Thank you very much. The meeting is adjourned. Thank you very much for your attendance. Thank you, administration.